Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar, where we will be discussing case law from the past financial year. My name is Tim Loos. I'm a senior lawyer at WorkCover Queensland, and I will be your host today. Before we begin, we would like to acknowledge and pay our respects to the Yagara and Turrbal peoples as the traditional custodians of the land in which we work and from which we are speaking today. We thank them and their elders past and present for their ongoing connection to land, waters, culture, and community. Joining me today at WorkCover Central is our guest presenter, Jamie McPherson, to my left, a partner at HBA Legal. We also have Elise in the room from our communications team, and Olga Sashko, another lawyer from WorkCover's legal team, in the room. We're running the webinar presentation through Teams today. On to some housekeeping. We record the session, and we will send you a link later on along with the slide pack. So all the slides you see on the screen, we'll send those through. We also send a short survey so you can give us some feedback about the presentation or some ideas for future presentations as well. We upload the recording to WorkCover's YouTube channel. You can go there and find all our past webinars as well in a common law playlist. And we send it out via socials as well. You may submit questions during the webinar. There's a Q&A button in the toolbar at the top, and we'll try to get to those at the end, time permitting. We've got some questions that we received from people when they registered. So we've got some that we'll start talking through, and then we'll see if we can get some other ones that come through. Try to avoid asking very specific questions. If you have specific questions about a particular claim or matter, we suggest you talk to the relationship manager for your company or a customer advisor who's been handling a matter for you. If you have any technical issues, please refer to the help information under the More button, which is in the toolbar at the top of the screen. Okay. Jamie McPherson is one of Queensland's leading insurance defendant lawyers. He has almost 30 years of experience in workers' compensation, as well as public liability, personal injury, occupational health, and safety and employment law. Jamie also advises employers under the WorkCover scheme in relation to safety compliance and the implementation of effective safety and governance systems and protocols. Welcome, Jamie. One last thing before I hand over to Jamie, just a reminder to our listeners that any information provided including in response to questions today by WorkCover or HBA Legal, is general information only and should not be taken as legal advice. That's all from me. I will pass over to you now. Thank you very much, Jamie.
Thanks, Tim, and welcome everyone to the webinar today. I've been asked to talk about some of the key cases that have happened over the last 12 months. So I've tried to sort of separate it out in some respect in terms of the liability cases, the quantum cases. There's a few cases on the limitation period I thought we'd look at, and then sort of finish up with, before we go to questions, on what I think are some of the key takeaways for employers from this year in review. In terms of the liability cases, we go to the next slide. There's a few that we're going to go through there, and I'll go through them slide by slide. But for those, just quickly, in terms of what I mean by liability, for those who've had common law claims brought against them, does WorkCover need to pay damages for this injury or not? So it's whether there's been negligence or a breach of statutory duty or a breach of contract or something of that nature. So when we're talking about liability, we're talking about it in that sense. And those who've attended these seminars before would be aware that the courts put a fairly high onus on employers in relation to what their duty is and how it needs to be discharged. So these cases that I'm going through today illustrate that, but they also illustrate how the courts, in some instances, will find in favour of an employer if the evidence doesn't substantiate a finding of negligence. So we'll go to the first slide of CCIG and Shockman. Now, this will be a case that's known to most people, and particularly those who are frequent flyers on these webinars, because it's been spoken about before. I'm talking today about the High Court decision in relation to CGIG Investments and Shockman. For those who aren't aware of the case, it's a case that surrounds a Hayman Island resort where two workers were living there as part of their employment and cohabitating a room on Hayman Island. The employee was a bar and food supervisor. The co-worker was a leading hand. So the employee who brought the claim was a more senior role than the other employee or the co-worker. As you can see from the slide, after a fairly significant night consuming alcohol, the co-employee, rather than the plaintiff, came home and began urinating in the respondent's face and mouth, which caused him to have a cataplectic attack. The key case, or the key point, if we go to the next slide, in this case was whether the employer was vicariously liable for the actions of that co-worker. And the earlier decisions in the Court of Appeal of Queensland held that there was in fact vicarious liability for those actions because there was a causal connection between the employment for the claimant being in the shared accommodation and the event which led to the injury. When it went to the High Court, they considered that, and what the key principles of where a finding of vicarious liability can be made and ought to be made. The leading case prior to, sorry, I should actually explain what vicarious liability is for those who don't understand, and that is that vicarious liability is when one person, and particularly in this case an employer, is liable for the negligent acts of another. In this case, a co-worker. Normally, if a co-worker does something in the course of their employment which is negligent, then an employer will be found vicariously liable for that employee's negligence. A typical case, which we would normally come across, because obviously this is quite atypical, would be, for instance, in a warehouse situation where a co-worker was driving a forklift, drove it negligently, and as a result of that, another worker was injured. In those circumstances, even if the employer had the best systems in the world in place and therefore itself didn't breach its duty to the worker who was injured, the fact that the co-worker drove negligently is enough for a finding of vicarious liability against the employer, and therefore for the employer to be found liable. So that's the principle of vicarious liability. Obviously, in Shockman, the point was whether the act of the co-worker coming home and urinating in the claimant's face was an act in the course of their employment. As I was leading to before, the previous case in the area was a case of the Prince Alfred College, which involved a historical sex abuse case out of South Australia. In that case, it was found that an employer could be vicariously liable for the wrongful acts of a worker in the circumstances where the work environment gave rise to an environment in which those acts could be committed. So the question was whether that principle applied to a case like this, where on one view of the law, the environment in which the wrongful act was committed was the quarters where they were living. Ultimately, the High Court held in this case, though, importantly, is that the law of vicarious liability didn't go that far, and that ultimately, for a finding of vicarious liability to be made out, there had to be more than a temporal connection in terms of the employment. And here it was found that what the worker or the co-worker was doing, not surprisingly, was far outside the scope of their employment, and therefore that connection couldn't be found. So that's an important case in terms of limiting the scope of vicarious liability going forward. And as I said, decided by the High Court, it's binding not only in Queensland but also in other states. So the take-home point, I guess, for employers there, if an employee does something which is far removed from their duty, then vicarious liability is unlikely to apply. The converse also applies, though, that if an employee does something which is properly connected to their duty as part of their employment, then the principle of vicarious liability remains, and an employer will be found liable for it. This is important as well in an industrial relations context, in that if an employer is aware that an employee is not following the rules, so to speak, in terms of the safety management system in place, they need to take action against that employee pursuant to those industrial relations policies and procedures that they've got in place. Otherwise, they're exposing themselves to a possible finding of vicarious liability for those actions. We'll move on to the next case then, which is the case of Manka versus Tees Australia. Again, a Court of Appeal of Queensland decision. Here, not surprisingly, being a Tees Australia employee, was working in a slaughterhouse and slipped on steps. The allegations were that the employer failed to clean the steps or provide adequate tools for the employees to clean the steps. The employer quite rightly accepted, because there was evidence of it, that the claimant did fall, but said that the reason for the fall was not because of any defective state of the steps, either in its design or its state of affairs in terms of there being blood or anything else on it, but because of the employee not using the handrail which was provided. The claim was initially dismissed by the trial judge and then went on the Court of Appeal. The court found for the employer in this case that the employer had in place a safe system of work, and the steps that were on site did not create foreseeable risk. The important thing in this case as well, if we go to the next slide, is that precaution must be taken in relation to risk assessments to identify all risks which are present on the work site. In this case, the employer was able to succeed on two bases. One is that they'd show that it had assessed all risks in relation to the work procedures and practices that were in place, but it was also found on an evidentiary basis as well, I should say, against Mr. Manka, because ultimately in his evidence, he conceded that there wasn't actually blood existing on the steps when he stood onto them, but rather he had blood in his boots, which he hadn't properly washed before disembarking the area that he was, which was a breach of the procedure that Tees voters had in place. So the court found that the causal circumstances which he pleaded in his case hadn't been made out. And in fact, if he'd followed the procedure which had been set out by Tees, then there wouldn't have been an incident. And hence they were able to be successful in that case. The next case I want to talk about was Townsville City Council and Hodges. It's not an employer-employee case, but it's important in terms of the concept of what's reasonably foreseeable and not. In that case, there was a claimant who tripped on a concealed hole in a park in Townsville. She sued the Townsville City Council for the injuries that she sustained in that case. In the first instance, the trial said that the system of inspection that the Townsville City Council had in place wasn't sufficient, and therefore there was a finding of negligence made against them. Townsville City Council appealed that, was successful. And the question for the Court of Appeal was whether the precautions taken by the council were reasonable in the circumstances. So it goes to that reasonable foreseeability issue. What the Court of Appeal found, that it was likely that even if further inspections had been undertaken of the park, they wouldn't have found the hole because of its characteristics, and that is that it was hidden and on a reasonable inspection wouldn't be able to be identified. So the court found in that one that even though there was a hazard, to use the correct terminology, that was present, being the hole, because of its nature of being concealed and not reasonably evident on a proper inspection of the park, then it was found that, that there was insufficient evidence to prove that the council was negligent, because even if a reasonable inspection had been carried out, then that hole wouldn't have been identified. Again, that case is important for employers in terms of the takeaway point, because you don't have to identify everything at a work site. You have to identify what's reasonable and make reasonable inspections. if you have evidence and are able to prove that those reasonable inspections and reasonable risk assessments were carried out but missed something, then you may still, in some circumstances, such as in this case, be successful in defending liability. On to the next case then is a case of Caselaw and Nortask and Dalby Biorefinery. This is one which we often find in the WorkCover world, where we have an employee of one entity who's working not at that employer's premises, but at someone else's premises and suffer an injury. That was the case here, where Nortask were working at the premises of Dalby Biorefinery. In WorkCover land, we will call Dalby Biorefinery a third party to the claim. The worker was descending a fixed ladder when they fell 10 metres or 8 to 10 metres to the ground, and that fixed ladder wasn't compliant with the Australian standard. Now, by a fixed ladder, what I mean there is it was actually not a ladder that had been taken into the workplace either by Nortask or by a refinery, but was fixed to a piece of plant within the refinery, and therefore was obviously a ladder which was under the ownership and control of the third party. Not surprisingly, with a fall from 8 to 10 metres, someone was liable, but the question in this case was who was liable. And so the case will be focused on what the proper proportion of liability between an employer and the third party ought to have been. In this case, which is a fairly normal finding in terms of that apportionment, the principal contractor was found 75% liable for the claimant's injuries, and the employer was found at 25% liable. Now, some may ask why an employer was still found 25% liable when the ladder wasn't theirs. The ladder was a fixture at the third-party premises, and ultimately the employer had no control over the state of that ladder or otherwise. What the court found is that, obviously, not surprisingly, Dalby Biorefinery had a duty and ample opportunity to fix the equipment prior to the employer turning up on site. But more importantly, it also, Nortask, upon arrival on the site, both to quote for the job and also in performance of the work, had an opportunity to look at where that work is being carried out at the third party premises and do a reasonable inspection. So to take it back to the Townsville City Council case, if Nortask had carried out a reasonable inspection of the premises, in this case, the court said they would have identified the defective ladder and prevented the work from occurring. So this is where those two cases could be differentiated in terms of the failure to do a reasonable inspection here led to the incident, whereas in the Townsville case, the failure to do an inspection didn't lead to the injury because the risk wasn't identifiable. So that's that decision. And I really, in terms of those learnings there, those who are working in the third-party premises should always be carrying out a safety check of the environment in which their workers are attending. This is obviously relevant not just to contractors who are working on third-party sites, but also labour hire agencies. A case that we're seeing, or cases that we're seeing lots of in the WorkCover space at the moment, is nursing agencies looking after aged care people at their premises, and what's necessary in terms of that obligation is not dissimilar to this, where an assessment needs to be carried out to identify what risks are at that those premises and to address them. The next case is a case of, again, Townsville City Council get a gong, Bilson versus Sonic Communications. Here it was a WorkCover type case where the worker was working for the contractor, Sonic, as a vacuum truck operator. He was working in conjunction with and in a crew of Townsville City Council employees. For those who don't understand, a vacuum truck operator is one that often is used to, for instance, excavate dirt around electricity lines or other service cables to prevent them being cut, and are quite common now in city council style work around roads, etc., where those services are likely to be found. In his evidence in this case, the plaintiff advised that he instructed council employees not to touch or move the hose. So his case was that it was specialist equipment that only he should touch, and the others should stay away from it. Contrary to that instruction, Townsville City Council employees did touch or move the hose, which ultimately led in him being struck in the face by it. So once again, the question here was whether the employer that Sonic Communications is liable or Townsville City Council is liable, or both. This is a district court decision in 2024. Importantly, and how it can be compared to the cases I've spoken about previously, no risk assessment was done in terms of what the Sonic had to do. Also, work method statement was conducted. So whilst the verbal instruction was given by the worker, the court found that Sonic Communications had no proper safety system in place. It was on that basis the employer was found liable. Again, to go back to a point that we've already discussed on the day, because of the actions of the co-worker or the Townsville City Council employee in touching the hose, Townsville City Council held vicariously liable for the actions of that employee. So regardless of whether Townsville City Council did as an organisation did anything wrong, in this case, it was found liable to 30% ultimately because of the actions of that co-worker. So here's an important case where we can see the co-owner's liability coming into effect to find a liability against the council in circumstances where it probably otherwise wouldn't have been found liable in this case. The next case is a strange case. In terms of, it's called Carey Schofield versus Hayes and Civio. This is a labour hire host employer arrangement where Hayes is with the labour hire agency and Civio is a host employer. The worker was injured when he stepped backwards to avoid being stung by a wasp, of all things. When he did so, he slipped on a bag. He was delivering rubbish or something, or collecting rubbish, I should say, not delivering it. But there's a bag that he himself had placed on the ground prior to having the issue with the wasp, and he stepped back onto onto the ground, onto that bag, and slipped over and hurt himself. What it found, if we go to the next slide, is that he suffered some fairly serious injuries, apparently, in terms of that slip. Strangely, it found that the court found that Hayes, as a labour hire agency, had an opportunity of detecting the deficiencies with Civio's system of work, but they failed to do so. It's unclear really what the deficiency in Civio's system of work was here, and particularly how it was causative of the loss, particularly when you think about the cases that we've gone through so far today. If we remember that the claimant stepped backwards to avoid being stung by a wasp and therefore stepped onto the bag and slipped, one wonders what defect in the Civio system could have been. Further to that, if Civio did have a defect in their system, how Hayes would have identified that. But in any event, the court in its wisdom found that an employer was 25% liable for the injury and Civio 75% liable. Realistically, that's a reality check for employers that whilst there's been some success in the courts over the last sort of 12 months in terms of liability, the courts still, as I sort of said at the outset to this presentation, the onus against employers is strong. Here, particularly where the court was unable to find any evidence of proper due diligence by Civio or Hayes on the Civio system, they found that breach of duty. As I said, the real question I find in this case is whether that breach, if identified, was actually the cause of the claimant's loss. The next case is a case of the Bishop and Compass Group. Again, this is a district court decision. The worker had a 6-month short-term contract as a kitchen utility assistant at a mining camp. So Compass Group is a fairly large and well-known catering organisation that does a lot of work in those camps and in other places. She suffered injuries to her right elbow, and I'll say there at some point in her employment because it wasn't clear that she suffered any frank injury. In this case, obviously, being an employee relationship, it was quite clear that there was a duty of care owed. The question was whether the plaintiff had actually been able to make out a breach of that duty, and finally, whether the breach was the actual cause of the injury that she sustained. In this case, a breach of duty was found in terms of the system that the employer had in place was not sufficient to safeguard against the risk of injury such as that suffered by the plaintiff in terms of her elbow injury, but and particularly it was in relation to a system of breaks or regular breaks for employees in terms of performing the work. What the court went on to find, though, importantly, was that that breach hadn't caused the injury that the claimant had suffered. So whilst the employer was negligent in the traditional sense, that negligence hadn't caused the injury for which the claimant sustained. And that's basically was found in the medical evidence which was adduced at trial to break that causal link. Why it's important is it does show that even though, and it's a bit of a theme that's been going throughout the cases today, even though a breach of duty may be pointed to and established, that's not sufficient to win. It's necessary to show that the breach was the cause of the plaintiff's injury. And I've got there, obviously, because you probably sensed my dislike for the Hayes case. You need to compare the decision of this one where there was a breach, but it wasn't causative of the claimant's injury, as opposed with Hayes, where there was a breach, but it was found to be causative of the claimant's injury, with a bit of an evidentiary gap in proving that breach and that connection. The last one I want to go through in terms of the liability side of things, and I was conscious of time, is a Sawyer and Steeplechase, which is a very, very recent decision of the Queensland Supreme Court. Here, the worker was performing a concreting task on a residential property. They suffered 2 separate injuries in 2016 and 2017. In the case, the worker brought a claim both against his employer, but also against the principal contractor on site. The injury that he sustained was lower back injury sustained by bending and reaching, holding mesh nets, and another would place those in position for the concrete slab. So the question there was, well, first of all, was there liability in the employer? And secondly, if there was there also liability in the principal contractor or head contractor? Ultimately, it was a pretty significant finding of damages of approximately $780,000 against the employer. Importantly, though, the claim against the head contractor was dismissed. And the reason for that is that ultimately the principal contractor engaged the employer to do the labour and to carry out the work. Ultimately, whilst the principal contractor was found to have obligations under the Workplace Health and Safety Act as being the organiser and controller of that site, the work that was being performed was solely within the ambit of the employer's subcontract and ultimately didn't involve either any other contractors or require any intervention from the principal contractor. So ultimately what was found is that the work that was being performed, and particularly the breach that occurred, was a breach by the employer and not by the principal contractor. The important learnings in that case is it's not always as simple as a 25-75 split in terms of a labour hire type case, or in terms of some of those other cases, the Townsville City Council case, where it was a 70-30 split. You've still got to be able to show when someone like a principal contractor or another entity or a third party is brought into the claim, you need to show a breach of that duty in terms of that third party or principal contractor, and that breach was a real and operative cause of the claimant's injury. In this case, whilst there was the third party on site, nothing that it did or didn't do or failed to do, as the case may be, had anything to do with how the claimant alleged and ultimately proved that they caused the injury. And therefore it escaped liability. Why that's also important for those who are in the webinar who are involved in the construction industry, when you're negotiating your contracts or doing contracts with a principal contractor or otherwise, the first thing that we look to in terms of running an argument like the one that we saw in Sawyer and Stillwell Chase is the scope of works of your contract. If the work is solely within the scope of works of what you've been assigned to do as a subcontractor, it's unlikely that a principal contractor will be liable. Where the work either forms part of your scope of works but not all, and potentially part of another contractor's, that's when a principal contractor's exposure comes in. A typical case is often where, for instance, on a high-rise construction site, the principal contractor is coordinating trades, and for instance, you may have one entity operating the crane as opposed to the employer who, for instance, like in this case, is a concreter on site. There, where there's other trades involved and other contractors involved, and there may be an injury suffered as a result of different competing causes because of those different contractors on site, that's where a decision like Sawyer and Stillwell Chase could be set to one side as not being applicable law. But we don't have that scenario of different operative sort of causes of the injury, and it really is the cause which is solely within the control of one contractor, then a decision like this would apply. Going over to quantum cases now, there's obviously, I'm time restricted in terms of quantum cases. I could do a whole seminar on quantum cases, but they are what they are in terms of what the courts have found. So I just wanted to go through a few today to sort of give some indication of what the courts are looking at in terms of damages. Now, again, in terms of what quantum means, it's the amount of damages that a person gets is the simplest answer. So the first step in obviously establishing a case against an employer is the liability aspect, which we've gone through exhaustively today. Once they overcome that hurdle, the court then needs to decide how much they should be awarded. And that's what we're talking about now in terms of some themes of the quantum cases. So there's liability and quantum. The first one I want to talk about is Kim Martin and Amica. Now, it's very particular in its circumstances, but it's noteworthy across the jurisdiction. It's a mesothelioma case against Amica, who basically took over the liabilities of James Hardy out of the 60s and 70s in terms of the manufacture of asbestos products. In this case, Amica was in fact also the employer of Mr. Martin. It's the first case where in the Supreme Court of Queensland where general damages have been awarded by the court for mesothelioma. And you can see there an award which is significant was allowed, where $200,000 was allowed for past general damages and $6,000 for future general damages. Now, this is in a scenario where general damages, for those who don't know, are what are otherwise regarded as damages for pain and suffering. So in a normal, not a normal case, but in an injury, for instance, where there's a back injury, the court awards an amount having regard to what the disability is and the pain that has been suffered from that back injury. Mesothelioma, obviously, it's an aggressive and terrible disease where someone's life is taken from them, often in a very, very short period. Notwithstanding that, the court awarded here over $800,000 for general damages. As I said, it's the first award for general damages in Queensland for mesothelioma. And regardless of whether it's for mesothelioma or not, it's the highest award of pain and suffering ever awarded in Australia across all jurisdictions. So the case is of significance from that perspective. Fortunately, for cases brought under the workers' comp system in Queensland, general damages are limited by virtue of the regulations, where a scale is put in place which provides for how much to be awarded for different cases, for different impairments based on what's called an ISD value. So fortunately, WorkCover has already taken steps and has for many years now to regulate what these general damages are, but it gives a clear impression, in my view, as to where the court will go if it's outside of those thresholds. The next case that I wanted to go through, I did have the case in there, the Avio case, sorry, not the Avio case, the Civio case in Hayes, but I've taken that out because I think I've sort of said enough in terms of it from a liability perspective. But suffice to say, if you wanted to ask me some questions about the quantum of that case, it's also significant from what the claim was awarded in quantum, because notwithstanding the extent of his injury, he still got a substantial award of particularly future economic loss in that case. I was going to move to Forostenko versus Spring-Free Trampolines Australia. This is important because it deals with, and again, it's based on the evidence, but it deals with future economic loss in a very interesting way. Again, in terms of what quantum is made up of, there's the general damages of which I've just spoken about, past economic loss, future economic loss, what we call special damages, which is generally out-of-pocket expenses, so pharmaceutical expenses or other sort of expenses that are incurred by a worker in recovering from their claim. When we go to settlement conference, it's often the head of damage called future economic loss, which is the most contentious, and that is it's the court making an award for what they think is a likely loss suffered by a worker into the future because of their lack of employment or loss of employment or loss of employment opportunity. In this case of Forostenko, the plaintiff was described by the judge as an avid user of spring-free trampolines. He was a physiotherapist. I have a spring-free trampoline in my backyard. I'm not sure if anyone's seen me live before, but I'm not an avid user of spring-free trampolines, not because there's anything wrong with them. It's just that I'm 150 kilos and we don't mix very well. In any event, Mr. Forostenko was a 41-year-old physiotherapist who basically was injured as a result of suffered a fractured foot because of a defect in the spring-free trampoline. It claimed damages, as you can see there, of nearly $4 million. It went to trial. Importantly, the injury was in 2017, and he didn't go. He was 41 years of age at the time of that incident, with 2 young children, one on the way. By the time it actually got to a trial in 2024, he was 48 years of age. Now, ultimately, he was successful in his claim against spring-free trampolines, and he was awarded close to $750,000 against them. Whilst it's significantly less than what he was asking for, it still is a significant award, as you understand. The real point here is, well, there's two. The real point here is that the plaintiff, Mr. Forostenko, was a 41-year-old physiotherapist who basically was injured as a result of suffered a fractured foot because of a defect in the spring-free trampoline. It claimed damages, as you can see there, of nearly $4 million. Because this took 7 years to go to trial, he got $388,000 for past economic loss, which is, again, a significant award, and is a important determination for what we look at as lawyers in terms of getting a matter resolved or to a trial as quickly as we can, which in terms of the 7-year period here enabled, in my view, that award to be inflated more than it otherwise would have been. The reason I say that is a future economic loss award for a 48-year-old physiotherapist was only $225,000. So it was less, even though he had another at least 12-year working life, probably 17 years. So far greater than the 7 years between the time of the incident and trial. The reason he was only awarded $225,000 is the court thought that he was over describing his symptoms, and that being a physiotherapist, he still had the ability to perform his work to the fullest extent, and otherwise retrain into other roles, for instance, managing the physiotherapy business as opposed to being a physiotherapist himself. The words used by the judge were that he could work on the business rather than in the business. The judge also found that he had other unrelated impairments which we would have precluded him from working till his complete working life in any event. But notwithstanding that, he's still awarded an amount for the next 4 to 5 years economic loss to allow him that time to retrain into other roles. And as I said, an award of $225,000 was awarded. Really, the point was here, and it was a great job done by the defendant lawyers in the case, is they presented the issues to cut down the future economic loss component of the claim in a systematic and sensible way, which allowed the judge to go through it, make a finding in relation to what that work capability was, which really did limit that award. So we can probably go to the next one now, which is the limitation cases. I'll run through these fairly quickly, but they are important. So again, for people who don't understand, normally for a claim in damages, whether it be a WorkCover claim or for any other personal injury, has to be brought within 3 years of the date of injury of the incident. The Limitation of Actions Act, which has been around for a very long time, allows for that 3-year period to be extended in circumstances where what's called a material factor of decisive nature occurs outside the 3-year period. And if that material factor of decisive nature is found, then a further 1 year from the timing of that material fact is granted for the claimant to commence proceedings. I should say, in relation to workers' compensation claims, there's also extensions within the Workers' Compensation Rehabilitation Act for circumstances where workers' compensation claims are ongoing in terms of the statutory phase within that 3-year period. I'm not talking about those extensions in this point. I'm talking about that original 3-year period and the 1-year extension under the Limitations of Actions Act. So we go to the next slide. The first case is a stay-at-age living and leave, where the worker was employed as assistant nursing and aged care facility. In 2015, she suffered a back injury. So for the injury to have occurred in 2015, the limitation period expired in 2018. She didn't see a lawyer until after that limitation period expired. They then applied for an extension of the limitation period on the basis of what I said before, a material factor of decisive nature. One of those facts was the surgery which she had in 2019, and she claimed that surgery in 2019 amounted to a material fact of a decisive nature. Initially, the court allowed that, but then it went on appeal. So we have a look at the next slide as to what the Court of Appeal found. They said that that surgery was not a material fact. The reason for that is the surgery was had not just in relation to that injury, but also in relation to a degenerative condition that suffered. And ultimately, the surgery was found to not be a decision. A material fact, I should say, needs to be something which, if not known to a worker or the plaintiff, wouldn't have caused them to regard their injury as significant. What they found here, there was not that the discretion was exercised incorrectly, but the discretion should have been exercised at all in the first place, because the material fact actually didn't exist and that the surgery didn't amount to material fact. So we will go on to the next one, where you'll see things are quite different. This is a medical negligence case from a pelvic mesh implant surgery which occurred in 2013. And again, the plaintiff commenced proceedings in 2018, and then the proceedings were transferred outside the 3-year limitation period. Extension of time for material factors once again sought. And if we go to the next slide, it was found that even though because she joined the class action in 2015 and had done everything she could to find out the material fact, and the material fact in this one was whether or not the surgery was negligent or something else, and the extension was therefore granted. So that was where the case where the material fact was found and the discretion was properly exercised. I'm just conscious of the time. We might go quickly to the next one. We might jump over the slide that obviously available. Is this last one? Is Personal Indigenous Land and Sea Corporation, a recent decision of the Supreme Court. That was a 2013 injury, and at the time brought a statutory claim against WorkCover, but a common law claim wasn't brought until 2022. That was on the basis of an expert advice that was provided, or an IME report by a specialist that said 50% of the claimant's injury was due to the 2013 injury, as opposed to a more recent injury where a 19% full person impairment was prescribed. As a result of that, if we go to the next slide, you'll see that the court was allowed that report was the first time that the 2013 injury was attributed to be the real and operative cause of the claimant's ongoing disability, in that case 50%. So the extension was granted. So that's it in terms of extension limitation periods. Before we go to questions, I think probably some of the take-home points from me, but I'm happy to discuss them more broadly, is that, as you can see from the liability cases, particularly that I've gone through today, the court, if armed with the right evidence, will properly look more closely at what is the real and operative cause of the claimant's accident in determining liability. So where is the breach? Who was responsible for that breach? And was that breach the cause of the claimant's injury? So in terms of preparing evidence for a case, those features are very important to establish. And they need to be established on evidence. And the easiest way to do that, obviously, is by the carrying out of a risk assessment and audits of the workplace. And if you have evidence of those risk assessments and control measures that are implemented as a result of those risk assessments in place and followed. Essentially, awards for future economic loss, even though that Spring-Free case was low in the scheme of things, for the amount of it for the period of time, I think is still quite a significant award. And again, credit to the defendant team who ran that case to be able to put the correct evidence or the best evidence possible before the trial judge to limit that future economic loss. But it was still an award of $225,000. And finally, in terms of the limitation periods, obviously the discretion, I think, from the courts to allow extensions is extending, and I think it will continue to do so. So thanks, Tim. Back over to you.
Thank you, Jamie. You said just before we started today that case law can be a bit dry at times, but I think you've handled it well and given people take-home points, which is really great. Some meaningful takeaways. These are the questions that came in earlier from registration. So we've put some up for discussion today. And some of this Jamie might have already covered in discussions today, but we'll just touch on each one now. So the first one, Jamie, are there any cases in the last year addressing the termination of employees whilst on WorkCover?
Yes, look, I've had a look. There's none that I'm aware of. The law in relation to the termination of employees on WorkCover is fairly settled, and that is you can't terminate an injured worker because of their injury within 12 months of that injury. You can terminate for other reasons, but regardless of the reason of termination, the advice that most lawyers would provide is that it's better, particularly if their WorkCover statutory claim is continuing, that termination doesn't occur, but that's ultimately a matter for the employer. Importantly, if that WorkCover claim is continuing, regardless of whether you terminate an employee or not, their entitlement to compensation continues post-termination.
232B, I think, is the section in the Act, if anyone wants to look it up for fun. Question 2, what's an employer's liability when it comes to agency staff? So I think you did talk about that in the context of a few of those claims, and I was conscious of that and wanted to leave this in, if only to bring it up and say, I think this is a bigger topic in itself, and I think we're trying to do an entire webinar on this somewhere between now and the end of the calendar year. But sorry, if you wanted to expand on what you'd said before or touch on it again.
Yeah, no, I think realistically the point in terms of, I agree with you, what is an employer's liability when it comes to agency staff is probably a topic for itself, but the principles that I think I've set out today in terms of liability apply is the short answer, and that is you need to have a look at when an employee of an agency, whether it's a nursing agency or a labour hire agency or any other agency, is injured. You need to have a look at what the real and operative cause of that injury is and where the breach lies, because that's what the court will consider, and either finding liability against the agency in the first place or against a third party, and if both, then what the appropriate apportionment between those two parties will be.
Question 3 is talking about developments in law in sort of two fairly separate areas. Again, you probably touched on this. So reasonably foreseeable is relevant to the liability discussion, and then reasonable management action is more relevant to determination of statutory benefits, whether a statutory claim is one that can be accepted because that RMA is an exclusion for psychological injuries. So the question is, have there been any developments in those two areas, developments in the way that's assessed or interpreted?
Yeah, look, thanks, Ian. I think in relation to the reasonably foreseeable, if that was what it was meant to be, I think I've dealt with that, particularly in terms of that Townsville City Council case, as to what the court are with that. In terms of reasonable management action, under Section 32(5) of the Act, obviously, and particularly a psychological or psychiatric injury is, or any other psychosocial injury is precluded from the Act if it arises out of reasonable management action taken in a reasonable way. Again, the law in that area is fairly well settled. There's been a number of cases over many years to determine what does amount and what doesn't amount to reasonable management action. But there's been no new cases on that I can find, at least in the last 12 months. I will say this, though, there is a focus, I think, in whether increased work activity or work requirements or work pressure amounts to management action, and if so, whether that management action is reasonable or not. And I point to a case there of which was only decided in February of this year of the state of Queensland, the Department of Agriculture and Fisheries versus the Workers' Compensation Regulator, where in that case they actually found that increased work didn't amount to management action.
Yeah, that's something we have to be very conscious of in determining claims with the RMA exclusion for psychological injuries. That first step of, is it actually management action before you consider whether it was reasonable and done reasonably. The last one we've got up there, it's a bit specific, but I think it leads to a discussion. How much weight does a private investigator's surveillance video of a supposedly fully incapacitated person moving and lifting like normal, how much weight does it carry in a common law case, and is it worth the financial investment?
The first thing I'd say in relation to that question is that an employer shouldn't be doing these because they're not privileged. And the reason I say privilege is that legal professional privilege applies to documents that are created for the purposes of litigation and don't necessarily need to be disclosed other than one of the exclusions or exceptions in the WorkCover Act. If an employer does these investigations themselves, they don't attach to any legal professional privilege and therefore must be disclosed as part of the pre-court proceeding stage. So any forensic advantage of this type of evidence is lost. That said, if it's done the right way through WorkCover, again, it depends, a bit like how long is a piece of string, but if the surveillance evidence ultimately, and there's many, many cases, Tim, as you know, where the surveillance evidence is at odds with what the claimant's reporting is and is at odds with what the medical evidence is, then a court will take it into account. In terms of whether it's worth the financial investment, again, I really can't comment on that because it depends ultimately on what the outcome of it is.
With the big, I suppose, hurdle tripping point with those investigations is often getting enough footage over a period of time. I think it can fail if the people see the claimants doing something on one day because it can be written off as a particularly good day. So it is a bit of an investment in a broader surveillance.
Yeah. What I would suggest to people, if they thought that there was an inconsistency, is probably the nicest way to put it, occurring, that they should talk to their WorkCover case manager and advise them of that, and then WorkCover itself will go and investigate where appropriate those circumstances.
Thank you. We did get some more questions that came through, but I'm conscious of time and we do actually have to finish at 11 on the dot due to some constraints on our end. So I might stop it there. Sorry, the only other thing I was going to say with that RMA question was if you go look at our YouTube webinars, I think a couple of webinars ago, we went into some more detail on RMA. You'll find that there. But sorry to the people who've submitted questions. I think we've just run out of time, so I might wrap up there. So thank you once again, Jamie. I appreciate you preparing and presenting, and you did a great job making the case law interesting. So just a reminder, I think at least we're setting it all up for us. Just a reminder that we've recorded this. It will be sent out to you. It will be uploaded to our YouTube channel. That's where you can find all our other webinars. We'll also get some feedback in a survey that we're sending out to you. If you're interested in attending any more webinars, keep an eye out on email, LinkedIn, on the events page on the Queensland website. And that's all from us today at WorkCover Queensland. Thank you so much for joining us.